Today, I'm going to give you 3 defenses you can use to crush junk debt buyers like Midland, Portfolio, Cavalry, and LVNV when they sue you in small claims court here in Florida. My name is Michael Waslick. I'm one of the lawyers at Ricardo and Waslick here in Florida, and together with my partner Jason Ricardo, I help people just like you overcome foreclosure and debt collection with dignity. And today I'm going to give you 3 defenses you can use to crush junk debt buyers like Midland, Portfolio, Cavalry, LVNV, and all the rest when they sue you in small claims court in Florida. And at the end of the video, I'm going to give you our secret weapon that we use to win cases without having to litigate any of these defenses. So stick around to the end. Now, if you have a question about anything I say in the video, leave a comment. We do our best to answer every comment either in the comment section or by shooting a new video. So go ahead and ask those questions in the comment section below. And at the end of the video, if this has been super helpful to you, please leave a like on the video so that other people can benefit from it. I'm going to move on now and give you the first of these 3 defenses. Number 1 is payment. If you have proof that you paid the debt that they are suing you for, that is almost always a slam dunk winner. I say almost always because sometimes there's going to be some cases where the evidence may not line up the way you expect, but if you have paid the debt and you can prove it, that is going to be a defense that you can use to crush a junk debt buyer that is suing you for debt. Now, I know this comes up sometimes because literally the day before shooting this video, I spoke to a lawyer in another state who says that they have a client going to court this morning and they're getting sued for a debt that they paid 5 years ago. So they're going to court, they're going to be litigating a payment defense. They're going to prove that they paid it off, that there's no debt owed. They're going to win, and they probably will have a right at the end of the day, unless they settle it, they probably have a right at the end of the day to sue for debt collection violations because the junk debt buyer is suing for a debt that's already been paid. Payment, great defense. That's number 1. Number 2, the defense of statute of limitations. Now, I've already shot a video about how much time a junk debt buyer or a debt collector has to sue you in court. And so in that video, I talked about how in Florida, the time limit is either 4 years or 5 years under most circumstances, depending on the claims and so on. And usually for a junk debt buyer lawsuit, they're suing on what's called account stated. That is a 4-year limitations period in Florida. Now, that time starts ticking from the time that the debt was last paid, from the time that the non-payment occurred. So if you last paid your credit card account more than 4 years ago and they sue you for it more than 4 years later, you can raise statute of limitations as a defense. And if you have the evidence to prove that time frame, you should be able to get that case dismissed. You should be able to get a judgment in your favor. One more important point about statute of limitations, it's an affirmative defense. It's your burden to prove that you have that time frame in your case. It's your burden to prove that the beginning of the time frame and the end of the time frame, and you have to know how to present the statute of limitations defense as a legal argument. I'm going to talk more about that in just a minute. But if you can do those things, then defense number 2, statute of limitations, can get your case thrown out for good. Judgment in your favor, game over, debt gone, goodbye, you'll never see it again. Defense number 3, and this is one of the most common that we see in junk debt buyer lawsuits. This is the one that is usually most likely to apply to all of you. You know, payment, that'll apply to some of you. Statute of limitations, that doesn't come up as often as it might, but number 3, standing, comes up in almost all of these junk debt buyer cases because junk debt buyers are not the original lender. They're not the party who you borrowed money from. And the word standing is simply the right to enforce the loan, the right to enforce the loan documents, the right to collect on the account. And if they are not the original lender, they have to prove that they have a right to enforce the loan. They have to prove a proper transfer of the loan from the original lender to the junk debt buyer. And the documents they need to prove that, they will have some of them attached to the complaint sometimes, and they will almost never bring the entire documents to court. They will almost never show you the documents that actually establish the transfer. And they will do their best actually to hide them. We're dealing with that right now with one of the big junk debt buyers. They are concealing the bill of sale, the forward flow agreement, all those agreements that show the transfer of the documents. And so they're not going to be able to prove standing without it. And so you're going to be able to contest that. And if you are successful, case over, case dismissed, judgment in your favor, you'll never see that debt again. Now, what is the secret weapon we use to get these cases thrown out before we even have to raise any of these defenses in court, without getting a court to rule on them, before a court has to rule on them? Well, the secret weapon is this. When we enter a case, the other side knows that it's going to be more expensive to litigate those issues than it will be to simply walk away in most cases. It's going to be less expensive for them to just give up, to just walk away from the debt, than it is to fight tooth and nail, hammer and tongs over these defenses, these legitimate, good faith, well-grounded defenses, well-grounded in facts and in law, that if we present them properly, they're going to have to spend time, effort, money to overcome them. Most likely, if we do it right, they're going to lose. And so they're going to spend a whole bunch of money litigating this for nothing. It's cheaper for them to just walk away. Now, that secret weapon is something you can use if the junk debt buyer is afraid of you, if the junk debt buyer knows that you know how to properly present those defenses, if you have someone in your corner, like a trained attorney, like someone who has experience in litigating these cases, or if you have demonstrated that you yourself know the rules of civil procedure, court procedure, you know the rules of evidence that will apply to keeping evidence out and getting your evidence in. And if you know the case law regarding the account stated, regarding the open account, regarding the breach of contract claim that a junk debt buyer may be presenting to the court, if you can show you know all those three things, the other side knows it's going to be more expensive to litigate than it will be just to walk away. That is the secret weapon that you can bring to court in order to get your case dismissed. So listen, if you have a question about anything I've said, please drop a comment. If this has been helpful for you, the one thing I'll ask you to do is leave a like. If you think you know someone who could benefit from this, please share it with that other person using the share button. And that's it. So hope it was helpful. Thanks for watching, and I'll see you on the next one.